Hey everybody, we're going live all over the place tonight. We're live on YouTube, we're live on Facebook, we're live everywhere. Hey, I need you guys to allow StreamYard to post your name. I need you guys to allow StreamYard to post your name when you guys make a comment. Otherwise, I have no idea who it is because it just shows as Facebook user. So if you're coming from Facebook, you need to click on that link that I just put in there and make sure that you give them permission. I'm going to leave it up there for a second. So copy and paste the link in there in your browser, and then it'll show up a button for you to click on. And when you click on that button, then you can leave comments and I can see who you are. Okay? So welcome to Advocates for Justice, Foreclosure Defense, Paralegal Service, Paralegal School. Advocates for Justice, we help you kick attorneys' butts. I know you call it whatever you want to, but we here and we about to get started. Tonight we are going to cover Vexatious Litigant. And then we're going to chop up the Vexatious Litigant Statute. And then we're going to chop up the rules too that they use for all of that. So I'm going to share with you, I'm also going to share with you the conversation that I would have with the judge. Yeah, that'll be interesting. So stick around for that. But before we jump into all of that, guys, I want to remind you guys to click on those annoying ads. Click on those annoying ads so I can get paid. When YouTube hooks me up and I start making the big money, I'm going to lower my prices so you guys can spend little money and more people will be able to fight to stay in their house. So that's my plan. I'm going to have YouTube pay me the big money for putting those ads on my channel, and then you guys will get a break when you're struggling to stay in your house. So make sure you click on those annoying ads, subscribe to my channel. All of these things let YouTube know that you find value in what I'm doing, especially the like button. Please click that like button, because when you click that like button, that causes the YouTube algorithms to show my stuff to more people, which means more people are going to find out that they have option. They have hope. That's what we want people to know. They have hope. And please leave a comment. Click the like button, leave a comment, and don't forget to ring that bell. Because when you ring that bell, you get notification the next time class starts, or the next time I upload a video, or whatever is going on at that time. So, and last but not least, please share my videos on your social media platforms. Yeah, share my videos on Twitter, on all your accounts, especially Facebook. The attorneys in California got Facebook to block me from advertising on their site, and the attorneys haven't figured out there's more than one way to get shit done. So you guys share my videos and share my live stream so people can see that they have options. And you got to remember too, a lot of times people may be facing these situations and need my help, but don't want to say nothing to you because they're your friends and they don't want everybody to know, they're a little embarrassed about being in a situation. So they may not come out and share this with you, but if they see something on your page that, you're endorsing, like I said, you don't have to admit to anything either. Hey, this guy's doing great work. Please post this on your Facebook pages and, just in case anybody needs him. That's it. So let's get started with class. So I get calls from folks all the time freaking out because the judge labeled you as a vexatious litigant. And I had one person in the group that was getting ready to change the way he was supposed to file his documents because he was afraid of this. They're going to block him from filing stuff. Okay, that's just crazy. First of all, the judge lies whenever their mouth's moving. Okay, that's how you tell when a bar member is lying, their mouth's moving. Or maybe they're breathing. That's another way to tell when they're lying, right? Yeah. You should not change the game plan unless they're trying to block you from filing your shit. Okay. Otherwise, you need to file the game plan. Don't all of these fear things that you're worried about them blocking you, being evicted, all of that. Don't worry about that shit. Okay. If you're in my program, you're here because you're willing to do whatever it takes. If you're willing to do whatever it takes, nothing the judge can say is going to be a problem for you. Okay. Because you're here willing to do whatever it takes. Now, the judge has no power to block you from filing stuff in your case to defend your property. And we're going to talk about this vexatious litigant crap here in a few minutes and what it means. So, first off, let me figure out how to do screen share. And we want to screen share that screen right there. Bam. There we go. So the screen share here, we're going to so the first thing we're going to look at is what vexatious means, because I think that's a good place to start on this. And I'm hoping when we do this, you'll see how this is done, and you'll do this before you call me freaking out. Okay, then you'll find out that you're wasting your time freaking out. Okay, so vexatious, and I love this. The state of being annoyed, frustrated, or worried. When we are annoying them, we are frustrating them, and we are making them worry, but I don't think this quite fits into exactly what they're trying to say of us. But I wanted to show you that because the way you figure this stuff out is you break it down. You break it down, do your homework. That's what I tell people all the time. Do your homework. So what is a vexatious litigant? Let's look that up. Hang on a second here. Okay, a vexatious litigant is a legal action in which is brought solely to harass or subdue an adversary. A legal action that is brought solely to harass or subdue an adversary. It may be in the form of a primary frivolous lawsuit, or it may be in the repetitiveness, burdensome, and unwanted filings of meritless motions in a matter that is otherwise materially cause of action. So basically what they're saying here is the underlying of what I just read here was that a vexatious litigant is not the defendant. Okay. Now, what they do all the time is they use half of this for something else and not the first half. So they're trying to say that you're filing burdensome, unwanted filings of meritless motions and all of that. That's just part of being a vexatious litigant. You can't have half of it without the first half. And you'll see when we go further here a little more information about this. So if you're filing these things and what you're filing has merit and is showing that the attorney and the judge are violating the law, then you don't fit in this category. So this this is interesting. This is interesting. Vexatious litigant, a person who brings action with no reasonable chance of success, where the object of the cause annoying to the opponents. So basically what this is saying here is that it is a person who brings an action with no reasonable chance of success, with the object of causing annoyance to the opponents. Such action may be struck out, and the court may order, upon application of the Attorney General, that no further legal pleadings be begun by the vexatious litigant without leave of court. So it's saying here that this can happen to you if by order of the Attorney General. It doesn't say the judge or the attorney. And it also says that it's when you file stupid shit that don't matter. Well, we're not doing that. So let's take a look at this definition. A vexatious litigant, legal proceedings started with malice and without cause. Legal proceedings started with malice and without cause. Vexatious litigant is meant to bother, embarrass, harass, or cause legal expenses to the defendant. It sounds like what they're saying that we are is what they are. Funny how it goes. So right here, it clearly says right here that a vexatious litigant is one who starts the proceedings with malice and without good cause. So we don't fit in that. I mean, clearly we don't fit in that. And you're not litigating to embarrass. Well, maybe we want to embarrass them, and we do want to cause them legal expenses, but not to the defendant. We want to cause this shit to the plaintiff. So now you can see a vexatious litigant is not the defendant who's about to get his house stolen and kicked out on the street. So it also says the plaintiff who starts such a litigation either knows or should reasonably know that no legal basis for the lawsuit exists. Damn, that sounds just like what the attorneys are doing. To obtain a remedy for a vexatious litigation, the injured party often files a claim for malicious prosecution. I've heard of that, but I didn't realize that is something you could do in civil court. Let's click on that. Oh, that's right. I took this as a Photoshop. So I clicked on that, and that is a cause of action, malicious prosecution. I'll have to look into that. Sounds like we might have another lawsuit package in the makings. Now, let's get back to work. Hey guys. Yeah, I can see a few people up in here now. Nice to have you guys checking in, because we about to rock and roll. William Johnson, welcome. James, BX Trust, glad you guys would drop in tonight. William says, what about the fraudulent birth certificates? What about them, William? That's not what we're discussing tonight. We talk about how we're going to stay in our house. Thanks, James. I have married and fit in my own category. Yeah, that's what people have been telling me. Not the married part, but about the fitting in my own category part. You're welcome, BX Trust. I do what I do because I love helping people kick attorneys in the face. So that's what my job is. And I am serious about it. So let's get back to the program here because we don't want to be all night here tonight. So you can clearly see that this term is used for the plaintiff that lost and is causing trouble, or it's used for the plaintiff that's filing stuff just to be a pain in the ass. It's not used for a defendant defending their property, trying to keep their family off the street. And at the end of the day, how can this shit apply to you when you're about to sue the judge for violating you? So if you're suing the judge for violating you, you got a right to be up in the house. They started it. Yep. That's the way I see it. They started it, so you're going to end it. Yeah. So you can't be a vexatious litigant if you're the defendant. And the court rules that do not comply with the Constitution or the federal civil rules of procedures are for attorneys to follow, not state citizens. And they have these court rules in place, in my opinion, to speed up the process and get your ass through their court faster than you need to be. And anytime the process is being sped up, you're getting the shaft. So I think everyone sees that, because you can't speed up the process without ignoring your rights. So in a nutshell, they are trying to hold you to the same standard as a licensed attorney when the Supreme Court has ruled that no state can license the practice of law. I think I've showed these notes before, but we're going to show them again because we can. So let's see what we got here. Oops, on the wrong screen. I'm going to bring it down here. So lawyers and attorneys are not licensed to practice law. The nature of the lawyer craft in America, United States Supreme Court rules that the practice of law cannot be licensed by any state. Swear versus the Board of Examiners. This is huge. This is huge. And I'm going to copy and paste this in the comment section after the stream is done. This is what I use when they get up in my face and try to say that I'm practicing law without a license, blah, 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 because the attorneys are whining. Yeah, that's what happens. The attorneys whine. And you can see here, that I think I've showed you guys this before. I got like 3 or 4 pages of these case laws. I save this shit when I'm doing research and I run across something, and I'll save it for later. This one's cool. The Bar Association is an unconstitutional monopoly on illegal enterprise. Criminal enterprise violates Article 2, Section 1 of the Separation Clause of the Power Clause of the Constitution. There is no power of authority for joining legislative, judicial, and executive within each state, as the Bar Association is attempting to do. Legislative branch of the government does not have constitutional power to issue court orders or any other kind of orders to people as a fiction court or a corporate court for profit and gain. So I'll copy and paste some of these in the comment section, and particularly the main one that you need. So if anybody's interested in doing what I'm doing, helping other people, this is what you need to know. Now, I have an online course that I've talked to you guys about. The online course is set up for property investors who have tenants who have not paid their rent because they maybe lost their job during the COVID, or the places in foreclosure, and attorneys and the bank attorneys already been screwing with them, trying to tell them that they need to get kicked out, so they're scared they're going to have to find another place that they haven't paid. Anyway, my new online course will help you all with that. The course is designed to where if you have more than one property in foreclosure, you can fight both. The foreclosures, or and keep everything separate. So if you have foreclosure in different processes, property in different processes of foreclosure, my online course will help you figure that out. And it's the best deal that I got going right now. And I want to make sure that I mentioned that. And if there's anybody that would like to learn how to do this, the online course would be perfect for you. And I have a new person that enrolled just yesterday. And that person kind of had a question: what happens if they're harassing? Well, dude, if they come after you for the unrightful practice of law without a license because you're using my stuff, I got your back. I got your back. And I'll tell you this: I'm still here. Okay, they've been trying to shut me. I haven't heard nothing from them in the last 2 or 3 years. I ran them hard on the last time they harassed me. Yeah. And I started filing some lawsuits all over the place and sending everybody notices of claims. And it's funny how it goes. When you learn how to sue people, they sit the hell down and leave you the hell alone. As corporations, all they care about is when you can cost them time and money. You cost them time and money, and they're going to have to rethink messing with you, okay? Because they ain't used to time and money. Miss J Ski, she said she'll be using this one's questions. I have the jurisdictional challenge with an affidavit is what we've been using to get everything stopped in state court. So that's going to be my suggestion to you, Miss J Ski. And then I also posted the lawsuit that we used to get the win against the judge. The judge just terminated the case, and I have that lawsuit on sale still. I have not put the package together. I have the lawsuit on sale still. So my suggestion, Ms. J Ski, is to stick that in the judge's face. That's my suggestion. To stick that in the judge's face. Let me post that in the comment section. Banners. Now, when you stick this in a judge's face, and you guys need to remember, when I put this together, it was like 1.5 years of filing stuff and back and forth with the judge, and we finally got the judge to go sit the hell down and terminate the case. And I had a person that was getting ready to use it. I thought, well, you haven't done all those things. Well, you stinking don't need to. You don't need to go through all of the 1.5 years of filing stuff that I did. If the judge is making decisions in your case and there's no injured party, if the judge is making decisions in your case and there's no original contract on the court record, then the judge is screwing up. Okay, the judge is screwing up. And you do not have to wait until you're evicted. If the judge is making decisions in the case, you can jam them up. If the judge ain't made no decisions in the case, but the case is filed on the record without the things necessary to give the court jurisdiction, file a lawsuit. Stick it in their face. But before I did that, I would object to the judge. I would also file a motion to recuse the judge. Now, that's if you have time. If you don't have time for that because they're about to push you off the cliff, then file your lawsuit and then file the rest of the stuff you need to finish slapping the judge in the face. That's how we roll up in here. And it's on sale still for $75 because I can. Who does that, right? You get a win. Actually, we got Shamel Maxwell. She's somebody from our Facebook group, and she is backing the judge up in the corner. She's from South Carolina, and man, they're really dirty over there. Yep. She filed her challenge jurisdiction in state court, and she filed all the other things, and the judge did not want to just give up. So the judge and the attorneys got together, and I think she stopped the sale 4 times. And the last time she stopped the sale, the new attorney sneaked in and they didn't notify them that the case was continuing or whatever. And they got the judge to grant the eviction. And Ralph, and we're addressing that right now. And we also filed a lawsuit against the judge. Well, we tried to file a lawsuit against the judge. And the clerk was involved because the clerk was manipulating the file. So now the clerk is refusing to file the lawsuit against the judge. So Shamel had the judge served. So the judge sent the process of service back because it wasn't file stamped. And I'm pretty sure the judge is directing the clerks not to file stamp it. And I guess they think that's gonna stop us, but it's not. So right now we're in the process of getting the marshals to serve the judge, and we're also in the process of doing a public service. And that's what you do, public service. You see, if they're trying to do all this stuff to get out of taking a lawsuit, then you just need to do public service and then file shit in court anyway. And when you have to look up the statute in your state for what constitutes a public service, usually you have to file it in the newspaper or something. And that's actually a good idea. I think it's a good idea to place your document, your lawsuit on the public record. It's like $10 to go to the courthouse and have them just place it on the public record. Okay. And then you take that file stamp copy that they stamp the thing on showing it's in the public record. And then you take that over and I would file it in court after I have it filed in the public record. Okay. Because now it's in commerce and they have to treat it different. And I'm still waiting to see how that goes. But that's what I would do. And that's what she's going to do. But, it's funny because the judge knows it's coming. They know it's coming. They've seen it. Violation of Administrative Procedures Act, violation of Foreign Registration Act. Yeah, and violation of Fair Debt Collection Act practice. And there's no way they can get out of it. They can stall it, but they're not getting out of it. So we're in the process of getting that served on them right now. So let's get back here so that I can finish up what we're talking about. So if you are in my program and you're about to sue the judge, it's not that if you're in the program, you're about to sue the judge anyway, he or she is going to have a much bigger problem than worrying about you being a vexatious litigant. So don't worry about that. Never be intimidated by the judge or by any bar members in court, because here's the deal. When they resort to intimidation, it's because you're kicking their ass. And if you're in my program, you're already ready to do whatever it takes to stay in your home. So don't freak out if they're going to name you a vexatious litigant or whatever they're going to call you. It don't matter, okay? Because if you're doing your job, they're going to be bitching. That's the way it goes. So get your lawsuit filed and stop playing around and make them answer to you. So now we're going to talk a little bit about How to make friends with the judge. I'm real good at that. So the first thing I would do in court is anytime the attorney opens his or her mouth, I would jump up and object. And when they get done laughing, you can tell them you're objecting because they have no witness and the attorney is not allowed to testify. Anything the attorney says is considered third-party hearsay because the attorney was not present at the time this original loan, this alleged loan was made. So anytime the attorney speaks, I would object. Now, you can't just object one time and expect that objection to hold for everything. I would keep objecting every time the attorney opens his mouth. I would keep objecting until the judge threatened to lock your ass up in jail. There is no witness to provide jurisdiction to the court. So without a witness, the court does not have jurisdiction to do shit. And I would make sure I got that on the record. There is no affidavit from an injured party. Without an affidavit from the injured party, there's no witness. And the judge is accepting liability by continuing to move forward with the case when there's no witness. And I would tell the judge that I believe I'm in an administrative court and not a judicial court. And then I would ask for the case to be terminated because you're revoking the consent to the proceedings. Now, I know they're probably not going to terminate it, but you want to get it on the record. They're going to be like, what? I would tell them I believe this because you're not allowing me any of my constitutional rights that I should be awarded if I was in Article 3 court. And then at the end of all of this, you want to ask them, is this an Article 3 court? The attorney is the only party who signed the foreclosure documents against your property. So the attorney is a plaintiff, illegally foreclosing, acting as a third-party debt collector. Remember, there's no affidavit. There's no signatures from anybody from the bank. Nobody signs any of the paperwork from the bank. The only signature on there is the attorney's. Oh, wait. They do illegally sign the promissory note after you leave the table when they stamp pay to the order of on it and process it through the Federal Reserve. They turn it into a security. And that alleged loan that they're saying they give you was created with your own signature. So the judge and the attorney in this case is in violation of the law. I would tell them, look, I never call them Your Honor. I call them by their last name like they're calling me. And I would let them know that you're in violation of federal law. You're violating the Administrative Procedures Act of 1946. You're in violation of the Foreign Agent Registration Act of 1938. You're in violation of Fair Debt Collection Act practice, RICO, money laundering, wire fraud. Just name the list. I would let the judge know that my legal team is in the process of preparing my $5.5 million lawsuit that I'll be filing in federal court to address the illegal taking of jurisdiction without an injured party. You want to keep it on the jurisdiction issue. You want to keep it at the gate. If you keep them at the gate, you're going to do a whole lot better. Because if you allow them to talk about all the shit that happened after you left the gate, you're screwed. Okay? Because all of that is fraud. So you can talk about it all you want to all day long, and you can complain about the servicer, and you can complain about this and that, and you're still going to be standing in a pile of shit when you're done. You want to keep it at the gate. The jurisdiction issue starts when they have an injured party. The other issue is that the foreclosure statute that they're using to foreclose on you does not have the necessary elements to make it a valid law. It's missing the enacting clause, the title, and the body. Yeah, we talked about that in a few other videos too. Their statute that they use for foreclosing on people's property is not a valid law. It's a statute. It's a rule. It's public policy. It's not a law. So now you don't have to wait for the judge to rule to sue him. You don't have to wait. If they got your case in there and they're moving forward like they got everything handled, they don't have a witness, they don't have an affidavit, they don't have what they need for the court to have jurisdiction, file your lawsuit. Stop playing around. We learn how to cut to the chase. The fact the court is entertaining an attorney's lawsuit without the proper documents to provide the court with jurisdiction is enough to sue the judge with. There you go. Remember, you're suing the judge for violating federal law, and just having the foreclosure on the court is all you need to sue the judge. Okay? You don't need to worry about following all those rules that the attorneys have been sticking in your face and all that stuff. No. Remember, when you sue the judge, especially when you do the paperwork, the judge's reconsideration package, and object, file your notice of claim, file your motion to recuse the judge, and then file your lawsuit, the judge is screwed. Okay, the judge can't come back in after the judge has been recused and have a lawsuit filed and all that. The judge needs to go find an attorney right now. And some other judge needs to come in. That's what happened in our case. Another judge had to come in. And that judge didn't come in. That judge just terminated the stuff right there. And it was over. They didn't even tell us. So we went on 4 more weeks filing stuff, not knowing that the case had been terminated. But that's how you do it. Now, that's about all I have for you guys tonight. I want to thank you for the privilege of your time. So now you can blow up the foreclosure against your property for only $75. And I wanted to get that. The link to that document posted, to that offer posted, so you guys will have it. $75. That's the bomb. Now, my other lawsuit packages were on sale last month. I have not changed them yet, but I'm thinking about it. So you guys still have opportunity to get the judicial and the non-judicial lawsuit package on sale for $300. It's still marked at $300. I'll probably leave it there for the rest of this weekend. And I want to also put the judicial foreclosure lawsuit package in the window. And Ralph, I see you, man. I'm about to stick it up on here. And it's still marked down as well. But it's not going to be forever. Okay, there's limited property tax lawsuit package. Now, I'd like you guys to share these packages on your social media, especially on Facebook, especially if you live in California, because the attorneys in California got really pissed about this limited property lawsuit package, limited property tax lawsuit package that I put together. And I haven't figured out if they're pissed because I'm exposing their fraud, or if they're pissed because the package was only $500. Well, now it's down $300. So I want you guys to post it so they'll see it. There you go. Limited property tax lawsuit package. What a deal. What a super deal. Now, I also have another package here that I'm going to post. Now this, I know some of you guys use your credit cards to make it through the pandemic crap when there was a shutdown. And now maybe you're a little worried about them harassing you or garnishing your wages for credit cards. Yeah, for the credit card bill. Well, I got this. And I'm going to put it on sale right now. It's on sale already. I'm going to put it on sale. It's at $2.99. I'm going to put this package on sale for the weekend. Okay, now this is 4/2, Saturday, Friday. This is Friday. Yeah, Friday. So Monday, this is going to go back up to the regular price. But right now, I'm marking it down to $150. So if you're facing, there was an error on that one. If you're facing this problem, this has been marked down to $150 for the next couple of days. So, and this credit card package is undefeated. So I'm just going to say that. And a lot of this stuff I put together for family members. And I put this together for a family member too. And it's undefeated. Hey, Marcy. Absolutely. You have to sue if you're in a non-judicial foreclosure, you have to sue the eviction judge, the magistrate judge, to get the door back opened up and stick that back in their face, what I sent you. Yes. You still sue them because that blocks that judge's decision. If you sue the judge that made the decision, then the decision gets blocked until the dispute's been settled. So yes, absolutely. And keep it simple. You only add the judge. Well, if you're suing the judge for taking jurisdiction without legal authority, then that would be the only person. Well, you want to have the state on there too, because you need the attorney general. You need to serve the attorney general. And we don't usually do that because I don't like to follow their rules. But what they've been doing is trying to block us from getting stuff filed and all that bullshit. So no, just go ahead and serve the attorney general, because whenever you serve something against a judge, you're supposed to serve the attorney general in the first place. And then that takes everything out of the attorney general's hands. No, I didn't read your comment, Ralph, about filing my paperwork with PS3 877. I don't know what any of that is. So I put together the program that I use using the real-time feedback from people in the group. So I already have the program set up how we need to do things and keep things simple. Now, that don't mean we can't change if I find something that I think is a value that's going to help. But most of the stuff that's connected with their system in the conventional sense is not helping anybody, and we don't use it. So Marcy, if you have any more questions, you can hit me up in the group or send me a private message. That's where I do the group coaching. So as you guys know, I don't really take phone calls from everybody, because if I did, I would be getting phone calls all day long from the 602 people in the group. Every time you got something in the mail, people would be calling me before they actually researched it, Googled it, looked at it, understood what it is, and put a game plan together for them. All that should be done before you call me, because I'm going to ask you, And if you haven't done any of that, then I'm going to send you to go do it, because I don't tell people what to do. I'm not an attorney. In my program, you're going to learn how to do this shit yourself. And you do that by knowing what's going on and putting together what you think is the plan that you need. And then if we communicate, we'll figure out if your plan is right. That gives me an opportunity to see where you're at, as opposed to when you call me up and say, "Hey, coach, I got this in the mail," or you message me, "I got this in the mail and I researched it and this is what I think it is and this is what I think I need to do about it." Now I have a good idea where you are in the picture, and if you're in the right place. If you're not in the right place, I'm gonna help you get in the right place, because you can't be getting your ass kicked in my program. Okay. J. Ralph says the postmaster has superior authority that supersedes any clerk and is deemed, sir, wants to. Oh, yeah, I know that, Ralph. I know that. And Shamel had this problem. I told her to make sure that when she sends stuff in, that she makes them sign for it. So when they sign for it and they go back and they leave it in the basket and say it's lost while they try to sell your shit, that don't work, because what we do is then that person that signed, we amend the complaint. We amend our lawsuit against them and that person that signed, that clerk that signed to the lawsuit, because that clerk that signed is responsible for making sure that shit gets posted on the same day that he picked it up. So we want to try and keep things simple too, and not make things too complicated. Tom Kibler mentioned in our group that you can, sue the sheriff and all that, and you could, but that's really not going to help you. I mean, it's just making more work, because when you got the judge ass on there, that's enough. The judge is the one that's taking jurisdiction out without legal authority, not the sheriff. Sheriff doing what the judge says. And yeah, I'm sure they all get a cut of the pie because that's the way the shit rolls. But so we're going to be on here tomorrow night, and I've got some more interesting stuff we're going to talk about, and I'll tell you guys about it tomorrow. Make sure that you guys grab that $75 document I'm telling you, okay? Even if you're not at the point where you need it now, you need to grab that document, because you're going to be suing a judge before this is over with, unless you plan on packing your shit. And I don't think nobody planning on packing that shit is in my group. So you guys need to grab that $75 document while it's available. And the property tax package also. Ralph, you need to grab that up, because that sale's going to be over. And when the sale's over, I don't want to hear anybody crying. Okay, let me be nice. So that's about all I got, guys. I will see you guys on the next stream tomorrow night after 9.